Are you one of the 67% of American adults who don't have a written will? And actually, if you're over 55 and older, you could be one of the 56% of American adults who don't have a written will. Well, I would like to give you 13 reasons that you need a will now. Hi, I'm Gail Jervis, and welcome to Life After 65. As an avid reader and researcher, I have recently made it my mission to explore all the ways my husband and I can live healthier, happier, and more fulfilling lives as we learn to redefine aging. I started the channel to share what I'm learning with anyone else who has that same goal. Now, here's the question. It's 1948. You're a farmer, pinned under your tractor. What's the first thing you think you would do? In 1948, the first thing that this Saskatchewan farmer, Cecil George Harris, did is think of his wife. But somehow he managed to take out his small knife from his pocket and he scratched a few words on the red tractor fender. Now you might immediately think that Cecil George somehow scratched out the words, "I love you." But instead, he showed his love for her by writing something else. He scratched out the words, "In case I die in this mess, I leave all to the wife." And then he signed it as best he could, scratching his name to seal his intent. You know, he had told his wife he'd be working until 10 p.m., but when he didn't return home, his wife got concerned and she found him trapped under this tractor. It was raining, and with great difficulty, farmers nearby finally got him released from the tractor, carried him into the back seat of a car, and took him to the hospital. But he was unconscious and he died the next day. Well, the next day, when his son was going to move the tractor, he saw his father's words etched on that fender, and therefore within weeks of his death, his estate passed uncontested to his wife. Otherwise, in 1948, without a will, his wife would have received the first $2,500 of the estate, but the remainder would have been divided to his wife and his children. So here's the question, if you don't have a will. Are you confident that your province or state will know how to divide your estate, at least in the manner that you had hoped? Or are you just hoping you can be like Cecil Harris and write a will just prior to your dying? Or perhaps you might relate to one of my uncles who just laughed when my dad told him he needs a will. And he says, "I'll be dead. I won't be here to worry about it." Well, in this episode, I will be sharing 13 reasons why you need a will, regardless of your income. But I will also share with you a few options so that no matter your income, you can also find it affordable. First reason, as I mentioned earlier, if you die without a will, the court will determine who will manage your estate. This includes bank accounts, real estate, car, and all valuables. With the government involved, the process can be lengthy and costly. Without a will, your assets may be distributed according to the state intestacy laws, which may not align with your preferences. You've probably heard of the famous story of Howard Hughes. He was an eccentric billionaire, and he died in 1976 without a will. Well, there were wills that appeared that needed to be contested, and there were more than 600 alleged relatives trying to get a piece of his estate. It wasn't until 1983 that Hughes' $2.5 billion estate was eventually split among 22 cousins. But in 1984, his estate paid an undisclosed amount to Terry Moore, who claimed that she and Hughes had secretly married on a yacht in international waters off Mexico in 1949, and they never divorced. But the Supreme Court of the United States ruled also that Hughes Aircraft was owned by the Howard Hughes Medical Institute and not to the relatives. Then in 1985, Hughes Aircraft was sold to General Motors for $5.2 billion. Now, I'm assuming you won't have as many alleged relatives looking for a piece of your estate, but it is a cautionary story that reminds us of the importance of a written will. Second reason, potential family disputes. The absence of a clear will can lead to disagreements among family members regarding asset distribution, potentially causing strained relationships. Family members may hire individual lawyers to contest the decisions, and there's the possibility of estranged relatives inheriting a share of your estate, contrary to your intentions. You know, Jimi Hendrix, he died in 1970 without a will. Well, the fight over his estate went on for more than 30 years, and his siblings have been continuing to feud because it got worse when their father, Al Hendrix, who had received much of the estate, died. And he left in a will that Jimmy's sister Janie would be in control of the $80 million estate. He at least had learned the importance of having a will. Now, Sonny Bono, you might know the name from Sonny and Cher back in the days of rock and roll. He died in 1998 without a will. His wife had to go through probate court to become the executor of his $1.7 million estate. But his estate was divided between his wife and his 2 children. In the meantime, another child came forward claiming to be from a previous relationship, but that was eventually proven to be false. But even Cher, his former musical partner, filed a claim for a piece of the estate. Did Sonny just make the mistake of assuming that his estate would just automatically go to his current wife if he died? Third reason to have a will, delay in asset distribution. The probate process may take longer without a will, causing delays in distributing assets to heirs. Or number 4, you can have higher legal costs. Without a will, legal fees associated with probate may increase due to the complexities of determining who are the rightful heirs. You know, in some provinces, the government probate fees or taxes are equal to a percentage of the value of the estate and will be paid out of the estate before beneficiaries are paid. However, probate fees in Alberta are based on the net value of property in the estate. For example, you'll be charged $400 if the estate is over $125,000. But if your estate is over $250,000, the probate fee will be $525. Now, actually, that is not a terrible price to pay, but without a will, there will be additional charges as a trustee will be appointed to decide who inherits the estate. For an estate that's fairly straightforward, you can expect a 1.5% fee for anything over $50,000. And plus, there are additional legal fees. Fifth reason, a statistic in 2013 indicates that in the United States, grandparents are primary caregivers to 6% of those children under age 6, 4% of children between 6 and 12, and another 3% are caregivers to children between 13 to 17. If you are one of those caregivers, do you want the government to decide who will be the designated guardian for your grandchildren? Sixth reason to have a will. Your charitable wishes may not be fulfilled. Without a will, any desire to leave assets to specific charities will most likely go unfulfilled. And number 8, loss of family heirlooms. Sentimental items may be distributed without consideration for their emotional value to some particular family members. Or they might have an estate sale, getting rid of everything. And these items may not have financial value, but to some people, some of those items had emotional value. I mean, who gets to inherit the family Bible? Who gets to inherit the wedding bands? Who will be fighting to get those special heirlooms? You know, my maternal grandmother, she died without a will, and her farm went to the 2 sons who still lived on the farm. But she had always told her one daughter that she could take any special items from the farmhouse when she was gone. However, her brothers told her that they didn't want anything taken out of Mom's farmhouse, even though she was asking for just a few simple possessions that were special to her because of their connection to her mom. And sadly, they were alcoholics, and when others visited, most of those special items were just taken. 8th reason. Without a will, you have no say in the final arrangements. Your preferences for funeral arrangements or organ donation may not be known or may not be honored without a clear directive and a will. 11th reason. If you are in a relationship but you're not married and your common law partner dies without a will, you could be omitted from the estate. Now, in British Columbia, Alberta, Saskatchewan, Nova Scotia, Quebec, Nunavut, and the Northwest Territories, they all recognize a common law partner as a spouse. But currently, in other provinces, Manitoba, Ontario, PEI, Newfoundland and Labrador, and the Yukon, only a married survivor is recognized as a spouse. And if you're separated from your spouse, you may not want them to be the recipient of any part of your estate. But since you're legally still married, that individual may likely receive part or all of your estate as determined by the courts if you die without a will. When singer Barry White died in 2003, he was separated, but he wasn't yet divorced from his wife. And she inherited everything. His live-in girlfriend of several years and his 9 children received nothing. 12. In Canada and the United States, the law recognizes adopted children or children by blood, but they don't recognize stepchildren. You could have raised your stepchild since she was young, considered her as one of your own children, but without a will, she would not inherit a share in your estate. 13. The Indian Act in Canada can affect survivors without a will. If the survivor is resident on a reserve, that person's estate is generally divided among the surviving spouse and children. Well, I hope I've given you enough reasons to make sure you have a will. But now what? There are 3 different ways you could approach writing a will. 1, if you have very few assets, you might just buy a self-guided write your own will workbook. They're usually about $29.95. Just be aware that each state and province has its own set of requirements which may not be properly reflected in these documents. Therefore, make sure you check on your state's or province's laws before you finalize your will. Also, make sure you have your will witnessed but signed by someone who isn't a relative. A second alternative, you could pay for an online estate planning service. And I realize that they charge about an average fee of $165. Now, once again, this is really only advisable if you have a straightforward will. Check out legalwills.ca if you're a Canadian. Or if you're an American, check out estateplanner.com. But I have no experience with this type of service, but it is an alternative for you to at least look into, and perhaps even you know somebody who has tried using this approach. The third approach to having a will is the traditional approach. See a lawyer. However, make sure you have gone online or even bought yourself a self-guided write your own will workbook, and you've already recorded everything you can think of that you want to have recorded in your will. In other words, try to minimize how much time the lawyer must spend with you, and that will help control your costs. But consider going to a lawyer if your assets are more complicated. For example, you might need to consider tax implications, or special bequests, or even guardian provisions for minor children. Also, your estate may involve complexities like owning a business, owning multiple properties, or even some international assets. Those things require a lawyer. Now, besides seeing a lawyer, you may also need a financial advisor to help structure your estate in such a way as to minimize taxes and fees on behalf of your beneficiaries. Canada has great tax incentives to encourage a legacy gift to a charity. And if you leave a legacy gift in your will, a tax credit will be granted to your estate for the gift value, which will effectively add a tax credit to your final income tax return. All these things can help maximize your estate value for your beneficiaries. Whew, this has been a rather heavy topic, so I decided to end this episode with a few more sentimental or perhaps even humorous will and testaments. Here's Anthony Scott, what he wrote in his last will and testament. He said, "To my first wife, Sue, whom I always promised to mention in my will." Hello, Sue. Or there's Sarah Clark of Bournemouth. She was directed in her will. "To my daughter, I leave £1 for the kindness and love she has never shown me." Or there's the very sweet and touching requirement in the last will and testament of Jack Benny, the comedian who died in 1974. And he says, "One red rose is to be delivered to my wife, Mary Livingston, every day for the rest of her life." And then there's the German poet Heinrich Heine, and he died in 1856. Now, he stated that his wife could receive his estate on the condition that she remarries, so that there will be at least one man to regret my death. Well, if you enjoyed this episode, make sure to check out the videos on the screen for more great content, and please click on the like button and perhaps even the subscribe button. Bye now.